Hello, and thank you for joining us for this series of videos on the Building Safety Bill. My name is Jenny Evans, and I am a solicitor here in the Housing Department at Anthony Gold.
And my name is Wallace White, and I'm also a solicitor in the housing team at Anthony Gold.
As I've said, we're going to be doing a series of videos on the Building Safety Bill. I will be doing an introduction to the bill, followed by some short videos on the role of the regulator, the building safety charge, and on remediation costs.
I'll be looking at the new regime for higher risk buildings, and that will include the concepts of the accountable person and duty holders. And I'll also be looking at redress through legal claims and strengthened obligations under the fire safety order. I'll then do a video with some concluding thoughts on the impact of the bill for various stakeholders. So we hope you find these videos useful.
Following the Grenfell Tower tragedy in 2017, it was widely acknowledged that building safety reform was urgently needed to prevent repetition of such a disaster. Some changes were brought in immediately, including the ban on combustible cladding materials on high-rise buildings. To tackle the more widespread systemic changes that were needed, Dame Judith Hackett was appointed to lead a review of building regulations and fire safety, with a focus on high-rise residential buildings. The review's final report set out over 50 recommendations for the government as to how they could deliver a more robust regulatory system. Hackett's report provides the basis of the new regime as set out in the Building Safety Bill. The bill was introduced in the Queen's speech in December 2019 with the purported aims to put in place new and enhanced regulatory regimes for building safety and construction products, and to ensure residents have a stronger voice in the system. A draft bill was published in July 2020, which was subject to pre-legislative scrutiny, and following this, more than 4 years after the Grenfell fire, the government published the Building Safety Bill in July 2021. The bill attempts to do a lot. It aims to improve accountability, risk management, and provide assurance. The bill intends to do this in a variety of ways: by the creation of a building safety regulator to oversee, advise, and enforce the new, more stringent regime for high-rise buildings; the introduction of stronger regulation for construction products; ensuring residents have a stronger voice in the new system, with more routes to raise their concerns about safety and to be able to hold those responsible to account; the creation of a new ombudsman scheme; increased access to redress through the Defective Premises Act 1972, through which residents can pursue builders for compensation for substandard or unsafe work; and strengthening of obligations under the Regulatory Reform Fire Safety Order 2005. And some attempts are made to address the crises faced by hundreds of thousands of leaseholders hit with bills for fire safety remediation works, which are for life-changing amounts of money. There'll be more on this later. The changes being introduced by the bill are wide-ranging and will affect developers, owners, managers, and occupiers of high-rise buildings, with around 12,000 residential buildings estimated to be in scope, around half of which are owned by social landlords. In this series of videos, we will discuss some of the key parts of the Building Safety Bill and whether the proposed changes are likely to achieve the purported aims of the bill. Please note that at the time of filming these videos, the bill was approaching its second reading in the House of Lords. Therefore, it is possible that the current draft of the bill will be further amended before it's expected to pass in mid-2022.
The Building Safety Bill establishes a new regime to regulate safety risk for higher risk buildings, so those which are at least 18 metres or 7 stories high and contain at least 2 residential units. In England, there's thought to be about 12,000 such buildings. A building safety risk is defined as a risk to the safety of people in and about the building, arising from the spread of fire or structural failure in particular. So the bill creates the concept of the accountable person, who is responsible for safety in these higher risk buildings. This is in line with the Hackett report, which recommended that there should be clear and identifiable duty holders with overall responsibility for fire and the structural safety of the building. The Hackett report was clear that buildings must be thought of as an integrated system and managed with a whole building approach. So the bill and the draft regulations set out a number of duty holders, including those who procure, design, and manage building work. These duty holders must consider and manage building safety risks throughout all stages of the building's life cycle, sharing information with the next duty holder along the process. And this is going to be known as the golden threads of information. The life cycle of the building will be split into 3 gateways or stages, and compliance must be demonstrated at each one. So the duty holders include the client, the principal designer, the principal contractor, the building safety manager, and the accountable person. The accountable person may be an individual, a corporate body, a management company, or a right to manage company. They will own the common parts or be under a relevant repairing obligation in relation to them. Where more than one accountable person exists, one will become the principal accountable person, and that will most likely be the freeholder. The principal accountable person must, firstly, register the building with the new regulator, assess risks and submit a safety case report, and thirdly, appoint a competent building safety manager to manage risks for the building on a day-to-day basis. The accountable person must also give the residents a greater voice in the management of the building safety. They must produce a residents' engagement strategy, setting out what information will be provided to residents and how they will be consulted about risks of fire and structural failure. They will also establish a complaint system, and they must provide information about the building safety to all residents. In turn, the residents will also be under new obligations, such as not to act in a way that creates a significant risk of fire or structural failure, and to comply with any reasonable request by the accountable person for information or access. And if a resident falls short of their obligations, the accountable person can issue a contravention notice, which in certain circumstances can be escalated to the county court. On the flip side, if the accountable person fails to comply with their duties, the Building Safety Regulator will have sanctions available, which include compliance notices, criminal prosecutions, and placing the building into special measures to ensure that safety obligations are met.
So the Building Safety Bill includes measures to create a building safety regulator in England. The regulator will head, implement, oversee and enforce the new regulatory regime for high-rise buildings in scope, which my colleague Wallace will discuss in more detail, but in summary means buildings with 7 or more stories, or that are 18 metres or higher and which have at least 2 residential units, or in the design and construction phase only are hospitals or care homes. The regulator will also more widely oversee the safety and performance of all buildings, so including those that do not fall within the definition of high-rise buildings in scope. The regulator will be established within the Health and Safety Executive, which is a UK government agency responsible for workplace health, safety and welfare. The regulator will be headed by a Chief Inspector of Buildings. It was recommended by Dame Judith Hackett that making the regulator part of the Health and Safety Executive, rather than being an independent body, would help the new regulator assemble at pace under the guidance of an established and experienced regulator. However, the regulator will have its own powers. It will need to make a strategic plan and its own programme of works. I will now look at the function of the regulator in a little more detail. 2 main aims of the regulator are to, number 1, secure the safety of people in or about buildings, and number 2, to improve the standards of buildings generally. So how will they do this? Well, the regulator's functions are extensive and include the following. So they have a role of implementation and overseeing. They will lead the delivery and implementation of the new regulatory regime for high-rise buildings. And they'll be responsible for the regulatory decisions during the design, construction, occupation and refurbishment of high-rise buildings. The regulator will become the building control authority in England for building work on high-rise buildings and will grant permission for and oversee building work, implementing specific gateway points at the design, construction and completion phases to ensure that safety is considered at each and every stage of the construction of a building, and to ensure that those who commission, design, and undertake building work are considering safety risk at every stage. Local authorities and registered building control approvers will remain the building control body for other buildings. However, the regulator will oversee their performance. The regulator will also oversee the safety and performance for all buildings, with a duty to keep the safety and standard of buildings under review. The regulator will facilitate improvement and promote the competence and organisational capability of professionals, tradespeople, and building control professionals working on all buildings in order to try and raise standards. The regulator also has an advisory role. The regulator will give expert advice to local regulators, landlords, and building owners, the construction and building design industry, and to residents. The regulator must also provide advice, assistance, and encouragement to the accountable person and building safety managers, helping them to facilitate their role of securing the safety of people in buildings. And my colleague Wallace will discuss in more detail the role of the accountable person and building safety manager and what their obligations are. In providing their advice and guidance and implementing other aspects of the new regime, such as in making regulatory decisions, the regulator will have powers to work with local and fire and rescue authorities. They must establish and maintain 3 expert committees, one of which is a residents panel. And the residents panel is meant to be a vehicle which can ensure that residents have a voice in the development of policy and strategy within the regulator. The regulator must, for example, consult the panel before revising or issuing any guidance to the residents of high-risk buildings about their rights under the Act. Finally, some further functions that are worth noting are that the regulator has the power to make proposals to the Secretary of State for making new regulations, and also that they have a duty to establish a voluntary reporting system for building safety information. I will now look at the regulator's enforcement role. The Building Safety Regulator will have a range of assessment and enforcement powers to ensure that those participating in the design, build, and refurbishment of buildings will be held to account and to ensure compliance with the building regulations. The bill clearly sets out the approach the regulator should take when enforcing safety standards. This is based on the principles of transparency, accountability, proportionality, and consistency. A fact sheet produced by the Health and Safety Executive provides more detail on how the regulator will try to comply with these principles. They say that the regulator's response will be proportionate to the safety risks and to the seriousness of any breach of the law. Regulatory intervention will be targeted on activities where there is high actual or potential harm arising from any breach, with firm action taken against those who repeatedly offend, act irresponsibly, or whose actions could cause serious harm. In judging how far duty holders have taken steps to reduce or mitigate safety risk, the regulator will balance the degree of risk against the money, time, or trouble needed to avert that risk in the particular circumstances, as well as the impact on any action on businesses and residents. They say that in turn, the regulator will expect that duty holders will adopt a sensible and proportionate approach to managing safety, focusing on significant risks. The regulator may authorise a suitably qualified person with investigatory powers for the purposes of ensuring compliance with the regulator's functions. And the bill creates offences for those who intentionally obstruct an authorised officer exercising one of their functions. In turn, there is a review and appeal procedure in the bill for those that are unhappy with certain decisions taken by the regulator. The regulator's enforcement approach will be set out in a published policy statement, and this statement will inform the exercise of discretion and professional judgment taken by the regulator and their staff. The regulator has a duty to enforce the provisions of the bill and has a range of sanctions at their disposal. They will be able to remove products from the market that present safety risk, issue compliance notices, which require an accountable person to either take specified steps or to take steps to remedy the breach of a regulation, and ultimately have powers to prosecute or use civil penalties for those that break the rules. It is through these powers and functions that the regulator is meant to fulfil its aims of securing the safety of those in high-risk buildings and improving building standards for all.
So another feature of the Building Safety Bill is that it aims to improve access to legal claims under the Defective Premises Act 1972, the DPA. Currently, under Section 1 of the DPA, owners or persons with an interest in a dwelling can bring claims against the builder for compensation for defective work done in the provision of the dwelling, which renders it not fit for habitation. Provision can refer to constructing a new property or converting an old property, for example, an office into blocks of flats. For these types of claims, the limitation period will be extended retrospectively from 6 years to 30 years, unless that would breach the human rights of the developer. So this means that people may be able to bring claims for work completed up to 30 years ago. And the bill also extends limitation prospectively, so for work completed in the future, from 6 to 15 years. The bill also broadens the scope of claims that can be brought under the DPA, which will now include refurbishment works done to an existing dwelling, not just the provision of the new dwelling. This is a significant addition. It means that contractors who undertake works on a relevant building will be required to ensure that it is fit for habitation when the work is completed, or otherwise they may face legal claims. Separately, the bill will finally bring into effect Section 38 of the Building Act 1984. This allows claims for compensation to be brought for physical damage, so either injury or damage to a property caused by a breach of building regulations. So, for example, if there is a fire or a resident develops a physical illness due to the state of the property, because building work did not meet building regulations at the time of the work being done, the homeowner will then be able to seek compensation from those responsible. The limitation for these claims will be 15 years, but this will not apply retrospectively. Lastly, the bill is designed to strengthen obligations under the Regulatory Reform Fire Safety Order 2005. The Fire Safety Order covers the management of fire safety in non-domestic premises, including the common parts of buildings containing 2 or more sets of domestic premises. It requires a responsible person, so generally the owner or managing agent, to assess fire risks and put in place safety measures to remove or mitigate them. In addition to these requirements, the Building Safety Bill requires responsible persons, who may or may not be the same entity as the accountable person, to provide residents with relevant and comprehensible information about fire safety matters, and for higher risk buildings, to ascertain if there is an accountable person and cooperate with them. Fines will be in place for non-compliance by the responsible person.
I will now look at the building safety charge. The building safety charge is payable by leaseholders with leases of over 7 years or more, regardless of whether they are an owner-occupier or renting to a tenant in a high-rise building, as defined by the bill. The charge cannot be levied to short-term renters or to social tenants. The building safety charge applies regardless of whether the leaseholder's landlord is a private landlord or a local authority or housing association. The charge is separate from and additional to the leaseholder's service charge. It allows for recovery of costs associated with the new legal duties that landlords and building owners must comply with to keep their buildings safe. Initially, to the alarm of leasehold campaign groups, the bill allowed landlords to recover historic building safety costs, even if the leases did not let them do so, and with no cap on costs. Thankfully, following much backlash and a recommendation from the Housing, Communities and Local Government Committee that this would be unacceptable and an abdication of responsibility, the bill was amended, and the costs of carrying out building safety works have been explicitly excluded from the building safety charge. So what does the building safety charge include? Well, there is a list of narrowly defined safety measures, the cost of which can be passed through the charge. And these include things like fees payable to the regulator, management costs, for example, appointing a building safety manager or preparing a strategy document. The government has estimated the average monthly cost of the building safety charge to a leaseholder to be between £9 and £26. However, this may be slightly more at the beginning when those accountable need to set up certain systems to comply with their obligations. The charges payable by leaseholders under the building safety charge are meant to be transparent, but leaseholders will have the right to challenge the reasonableness of the building safety charges in the same way that they can challenge service charges. The Building Safety Bill does not make leaseholders liable for the costs of undertaking works to remedy fire safety defects, for example, by removing unsafe cladding. However, there is nothing in the bill at present to stop landlords continuing to pass these costs to leaseholders by their service charge, if this is allowed for in their lease. The bill does require landlords of all buildings, so no height restrictions here, who are carrying out remediation works, to take reasonable steps to recover the cost of remedial works from available grants or by pursuing third parties before putting them through the service charge. What constitutes reasonable steps has not been defined, and overall this may not take us further than provided for by existing law on claiming from warranties or insurance policies. However, failure by a landlord to take these steps does allow a leaseholder to argue that some or all of the service charge should be disallowed. So things were looking pretty disappointing. Following years of intense debate on the topic and contradicting previous government promises on the matter, the government appeared to be washing its hands of the crisis facing leaseholder, with nothing to force developers to pay. That was until a couple of weeks ago, when Michael Gove, the Secretary of State for Levelling Up Housing and Communities, put the focus firmly back on the developers and manufacturers. What Gove promised was a £4 billion fund for cladding remediation costs for buildings between 11 and 18 metres. With the money for this fund to be raised directly from developers and manufacturers, who have until early March this year to come up with a fully funded plan of action. Funding already exists for the removal of dangerous cladding for buildings over 18 metres. However, what this new funding announced by Gove does not cover are costs relating to other fire safety issues, such as wooden balconies, defective fire doors, and missing fire breaks, which many leaseholders will still face huge bills for. So both funds relate only to cladding remediation costs. Accordingly, the most significant promise made by Gove was that the government would work to consider further amendments to the bill to stop recovery of all fire safety remediation costs from leaseholders, so not just cladding. The detail of such an amendment is currently unclear. It doesn't appear to apply retrospectively, so for those leaseholders that have already paid remediation costs, and it is not known whether it will include interim costs, for example, the cost of a waking watch. And what about those faced with demands for charges prior to the bill being passed? There was a vague commitment to ensure leaseholders are protected from forfeiture and eviction due to historic fire safety costs, but this would require legislation. While many questions still remain, the recent government sea change is welcome, and it is hoped that in the coming weeks and months, further amendments to the bill will be drafted that will bring leaseholders some relief.
So a few concluding thoughts on the Building Safety Bill. The bill was created, as we know, in response to Grenfell and the subsequent Hackett report, which concluded that fire safety systems for buildings across the country were generally not fit for purpose. The changes proposed by the bill, for the most part, are an improvement to the regulatory landscape and should drive a healthier culture focused on a whole building approach to fire safety. Many stakeholders will be affected. For those living in higher risk buildings, the existence of the accountable person and the requirement for a residents' engagement strategy means that they should be able to raise concerns directly to the owners or managers of the building, who will be obliged to listen to them or potentially face criminal liability. This is important, as it is usually those living in the building who are most and first affected by fire safety and structural concerns. For leaseholders, in terms of respite for remediation costs, landlords are only required by the bill to take reasonable steps to explore alternative ways of meeting costs before just passing these on to leaseholders through service charges. It's not clear what the reasonable steps will look like in practice. There are a number of questions surrounding the recently announced £4 billion cladding remediation fund, including exactly who will pay into it, what it will cover, and whether it will extend to reimburse costs already paid. Those seeking redress who wish to bring legal claims under the DPA for faulty builds will have up to 5 times longer to claim. They may also be able to bring claims for refurbishment works, which is a significant addition. However, very few developers are likely to still be trading and solvent either 15 or 30 years after the works are finished. Developers often build through special purpose vehicles, which can be quickly wound up, and these types of vehicles are only likely to be used more in the face of greater potential liability. For claimants, the usual risk of litigation are still present, and there's no guarantee of a favourable outcome, even after incurring substantial legal costs. Regarding the human rights defence to extended limitation claims, we have yet to see what a developer would need to prove to successfully plead this defence, and that may mean a lot of claims put on hold while a test case works its way through the system. And for those involved in the construction process, for builders and developers, the bill may mean more work to do at greater cost, more delays, closer monitoring, and greater liability for claims, which will affect insurance cover. Architects, developers, and contractors will be under more duties, with tougher sanctions for non-compliance. Regarding the Ombudsman and the new regulator, who will have stricter sanctions available for breaches of building regulations and the gateway requirements, only time will tell whether they take a proactive approach to enforcing the sanctions, and much will depend on the funding and the resources available to them. So there is much to look out for. The bill is currently going through the House of Lords and is likely to pass into law in April to July of this year, 2022. Key changes will take 12 to 18 months to be enforced, so we are looking at summer 2023 to early 2024 before the changes start to be seen.